Fiduciaries are responsible for complying with the various notice and disclosure requirements that are mandated under ERISA. The intent of these disclosures is to provide employees with sufficient information about the plan so that they can make informed decisions about their participation in the plan and the investments. This module explains the various disclosure requirements as well as the Department of Labor's guidance about providing those disclosures in an electronic format. So let's start with a discussion about basic plan and account information in terms of notices and required distributions. Under ERISA, eligible employees and participants must be provided with various documents describing the basic terms of the plan and how to participate, as well as a statement regarding the participant's account under the plan. First is a summary plan description, and an SPD is a plain language summary to be provided to all eligible employees within 90 days of becoming eligible. Summary of material modifications made to the plan during the plan year. Summary annual report is a summary of the information contained in the plan's Form 5500, and it must be provided 9 months after the end of the year. Plan document must be provided to all participants within 30 days of request, and a periodic pension benefit statement must be provided each quarter. Section 404C disclosures of ERISA requires that participants to be provided with certain disclosures regarding fees and investments which are offered under the plan so participants may make informed decisions about the investments of their plan accounts. 404C is that ERISA section, if compliance is achieved, provides plan fiduciaries with defense. In other words, they can't be successfully litigated against based on participants making inappropriate or imprudent investment decisions. That's a great protection to have, but it's not easy to know if you're in compliance with 404C. The only way to know for sure is if the court tells you that you're in compliance, and usually it's with specific reference to an aspect of 404C, which you're being litigated for. Disclosures are required to be provided to participants prior to the time they may give investment instructions, as well as upon request. So before they're in the plan is probably the best way to put it. It's only required to be distributed annually, but we highly recommend that it's distributed again periodically. Doesn't have to be every year, but it's more defense for the plan fiduciaries to say our procedural practice is to distribute them every other year along with other required disclosures so that participants have reminder of this 404C compliance. Section 404A5 fee disclosures must provide to plan investment information on an annual basis. The following plan-related information is required to be disclosed and is an explanation of how to provide investment instructions, including any limitations on how to exercise voting tender and similar rights. Next is an identification of designated investment alternatives, including description of any brokerage windows. Remember, QDIAs or designated investment alternatives that must be monitored by the plan fiduciary. An explanation of the plan's administrative cost, including record keeping, accounting, legal fees, etc. Also, an explanation of fees that may be charged against an individual's account for services such as loan processing, quadros, investment advice, etc. And participants must receive a quarterly statement of the dollar amount of administrative and fees associated to their account. Qualified investment alternative notice. Participants must receive advance notice describing the circumstances for which their contributions to the plan may be invested in a QDIA, along with the right to change investments out of the QDIA. Notice required 30 days prior to eligibility, as well as annually. The blackout notice is for participants and required at least 30 days, but no more than 60 days in advance when there is a temporary suspension of the participant's ability to change investments, request a loan, or a distribution for 3 days or more. Automatic contribution arrangement notice. This is a notice describing rights and obligations when a participant is subject to an automatic enrollment feature. And a reasonable time period here is 30 days in advance.